Dear colleagues, dear guests, please allow me to continue with our committee meeting. We stick to the issue, anti-corruption policy, and we are now entering into the second round of our conversation with a workshop. The workshop is called Towards an International Anti-Corruption Court, ? Let me welcome my colleagues here in the room, all people online, as well as our excellent experts we have invited today as our guest speakers. You very much know that on the 17th February 2022, the European Parliament recommended to advance discussions about an international infrastructure to address the impunity of powerful individuals involved in large-scale corruption and to explore the possible establishment of an international anti-corruption court. In its resolution of 18th of January this year, the European Parliament adopted again a favourable position and called for the creation of an international anti-corruption court under the supervision of the United Nations to be worked towards. Our first expert today is Cedric Ringgaard, Professor of Public International Law in Utrecht University in the Netherlands. Professor Ringgaard has produced a study, a paper, a briefing for the Policy Department of External Relations on request of our subcommittee. It looks like that, wonderful piece, and available online. So, Professor Ringgaard, you have the floor.
Thank you, Mr. Chairman. Thank you for inviting me here. And indeed, I'm the author of a briefing on the potential establishment of an international anti-corruption court, but also on strengthening other existing anti-corruption mechanisms or new mechanisms to be developed. Let me start by saying a few things about the court, and Judge Wolf here on my left, one of the promoters of the court, will say much more about this. And indeed, I would like to emphasize that this Parliament has supported the establishment of the court in its resolution of 18th January this year, when it adopted its 2022 annual report on human rights and democracy. If we could perhaps go to slide number 3, then even the next slide. Yeah, perfect. Thank you. So I will flag first 3 design issues in relation to the court without becoming too technical necessarily. So you see them on the screen, and I believe that these issues are also relevant for the fight against global corruption more generally. So the court, if it is ever established, is likely to have jurisdiction over what is called acts of grand corruption, grand rather than petty corruption. So it will probably be important to adopt an international definition of the concept. What are we talking about here? And that is also relevant outside this very specific context of the court, I believe. So what are we talking about? Well, grand corruption relates to systemic institutional corruption on a grand scale. We're talking about kleptocratic regimes and corruption with far-reaching consequences for the enjoyment of human rights. So I would really like to stress also this link between corruption and human rights. The court is likely to have territorial jurisdiction, and in fact, this territoriality principle creates a lot of opportunities because it suffices that just one element of a transnational corrupt activity takes place in the territory of a state party, a party to the statute of that court. And also it allows the court to exercise jurisdiction over money laundering, the laundering of money in a state party, even if the predicate offence, the underlying act of corruption, has taken place elsewhere in a state which is not a party to the statute. So in fact, on closer inspection, you do not need that many parties to that court for it to be successful. And Judge Wolf may perhaps say more about this, but indeed it may be enough to have the global financial centers on board to pull this off. Third, there is a vexed question here of immunities of state officials. Immunities are impediments to the prosecution of foreign state officials precisely because of their official capacity. And I believe that it would perhaps be appropriate that states at one point signal that immunities never apply to anti-corruption prosecutions of foreign state officials, whether this happens before domestic courts or before international courts. Now, the International Law Commission of the United Nations has recently, in 2022, suggested that acts of corruption are in fact carried out for private gain. Hence, they are not official acts, they're not covered by functional immunity, which means that officials can and should be prosecuted for corrupt acts. If we go to the next slide, there are pros and cons regarding the establishment of this court, and I'll leave that to the discussion. There are issues of feasibility and resources, and I'm happy to return to this issue after the other speakers have taken the floor. At this point, I would like to stress that a focus on the court should not detract from the necessity to also strengthen existing mechanisms of fighting corruption. And in the briefing, I make a distinction between direct and indirect accountability mechanisms. Starting perhaps with direct accountability mechanisms, you see a list on the screen. First, extraterritorial jurisdiction. Now, there's a lot of talk about universal jurisdiction, so every state needs to have jurisdiction wherever the offense has happened, so also in relation to corruption, not just international crimes. But I myself am not entirely convinced. I believe that the existing grounds of domestic jurisdiction could be used more often, such as territoriality, go after money laundering, go after territorial facilitation, etc. So the problem here is not so much a lack of regulation or a lack of jurisdictional base, but the problem is really a lack of enforcement of existing law. Second, regional and international enforcement agencies. There's a lot to say about this, but being here in the European Parliament, I can say that I expect a lot from the European Public Prosecutor's Office, the EPO, which has started its first investigation also in relation to corruption and COVID-related public procurement. I also expect a lot from Interpol, which has recently established a new anti-corruption centre. As to national bodies that are internationally supported, there's more information in the briefing, and I write a few lines on CICIG in Guatemala, but we will have a speaker later on CICIG, so I'm not going to address this in detail here. This is often cited as a best practice, but I think more research needs to be done regarding why exactly that has been the case. Regarding international courts other than this IACC, than the International Anti-Corruption Court, now there's a first case pending before the International Court of Justice regarding corruption since late last year. Quite interesting, as a country in Africa, Equatorial Guinea, alleging that France is failing to comply with its obligations under the UN Convention Against Corruption, its asset recovery obligations. So let's see where this issue strands. I think the International Court of Justice could be used more often, and also human rights courts like the European Court of Human Rights can be used to provide accountability for corruption in connection with human rights violations. So again, I stress this link between corruption and human rights. Regarding indirect accountability mechanisms, first, I believe that states and also the EU could make more use of anti-corruption clauses in bilateral trade agreements, and compliance obviously needs to be monitored. Second, and you've discussed this before, I understand, in the previous session, anti-corruption sanctions. The EU is studying this. I'm not going to discuss this in detail. Third, one can contemplate a UN Special Rapporteur on financial crime, corruption and human rights, looking at the linkages between these. And fourth and final, I think more can and needs to be done in terms of asset recovery, better international coordination, more agreements on the return of proceeds to the victimized populations. And we may perhaps also want to enable confiscation without a prior conviction and confiscation of unexplained wealth that is linked to criminal activities. I'm aware that there are fundamental rights issues at stake here, but still, there is an EU Commission proposal 2022 in this regard, which your Parliament is currently also looking at. And finally, we may also need to push for the adoption of a global financial registry on ultimate beneficial owners, the so-called UBOs, and such a registry may dismantle offshore havens which thrive on registering shell companies that are established by corrupt persons. And I think important steps in this regard have already been taken also in the EU, but the Court of Justice has recently decided that relevant information on UBOs should not be made available to the public, citing privacy concerns. So finding a balance between fighting corruption and protecting fundamental rights is becoming a key issue that also requires the sustained attention of your Parliament. And I think it's something which your Parliament in its trilogue negotiations with the Council and the Commission regarding the 6th Anti-Money Laundering Directive may want to address. Fifth and final slide, I conclude, your Parliament may want to think through the institutional design of an international anti-corruption court, and the Parliament should continue to support other accountability mechanisms. Thank you for your attention.
Thank you so much, Professor Ringert, for this holistic presentation and for the study and opening up the debate in this workshop. The idea of an international anti-corruption court is a core message by Integrity Initiatives International, a civil society organization based in the US. Judge Mark Wolf, chair of Integrity Initiatives, an originator of the proposal, will present recent developments now to us, recent developments in the campaign for the court as an instrument to combat grand corruption. Please, you have the floor.
Thank you very much. Thank you for the resolution of the European Parliament calling to work toward the creation of the International Anti-Corruption Court. Thank you for this workshop and the opportunity to discuss it. And thank you also for Professor Reingert's excellent paper. I am a senior United States district judge in Boston, Massachusetts. I'm here as chair of Integrity Initiatives International, as you said. I'm accompanied by the two of my co-chairs, the two co-chairs with me of the international campaign to create this court. Augusto Lopez Claros of Spain, a former high official, economist in the World Bank, and the chair of the Global Governance Forum, and Maya Graf, distinguished like Professor Reingart, the international lawyer, law scholar in The Hague, and the co-convener of the Climate Governance Commission with Mary Robinson, among others. Maya and a vice chair of III, Justice Richard Goldstone of South Africa, are chairing a group of international experts from around the world who are developing a model treaty to address all of the issues that Professor Reingert identifies in his fine paper.
So welcome all of you.
Thank you very much. We've been made to feel very welcome. The mission of III, as we call it, is to strengthen the enforcement of criminal laws against kleptocrats, corrupt leaders. And we do that in a range of ways. But we're best known, and the focus today is on our catalyzing and coordinating a campaign for the International Anti-Corruption Court. I'll say quickly, and perhaps we'll discuss it later, we also support all of the measures that have been identified. The effort to sanction corruption, the way human rights abuses are sanctioned, is a very good idea. And indeed, one of our partners and principal advisors is Bill Browder, the progenitor of the Magnitsky Act. I'm intrigued and encouraged by the creation of the European Public Prosecutor's Office, although I'm concerned that you may find that if cases are developed against very high-level officials, they'll have to be tried in corrupt state national courts. One of the major activities of Integrity Initiatives International has been supporting combating corruption in Ukraine. I've worked closely in the creation with Ukrainian leaders in the creation of its special national anti-corruption court and mentoring its judges. I should have 5 of them with me in Boston in September. The hybrids like CSIG have promise, but when they start doing a good job, they get ended, as I think we'll hear later. In regional anti-corruption courts are an appealing idea, but they seem to be extremely difficult to create. If I may say so, III and I particularly actively support the creation of a special tribunal for aggression, and I commend the European leadership on this issue. Vladimir Putin epitomizes the fact that kleptocrats are the worst abusers of human rights. And Gordon Brown, the former UK Prime Minister, is a big, energetic advocate of the Special Tribunal for Aggression. And he also wrote an article last March in the Times of London stating, we need an international anti-corruption court to hold Putin accountable. Simply stated, the argument for the International Anti-Corruption Court is as follows. Grand corruption, the abuse of public office for private gain by a nation's leaders and their private enablers who conspire with them, has devastating consequences with international impacts. And in papers that we've published, they're recited, but for the purposes of today, we always discuss first the horrible effect that grand corruption has on the human rights of people around the world. When she was the UN High Commissioner for Human Rights, Navi Pillay said, corruption kills. The amount lost to corruption every year could feed the world's hungry 80 times over. And that's the reason she's assisting us in drafting the treaty for the court. It's very important to understand that grand corruption does not exist because of a lack of laws. And I was pleased to hear Professor Reingart indicate this. There's 181 countries that are members of the United Nations and parties to the United Nations Convention Against Corruption. All 181 of those countries have laws required by the UNCAC criminalizing bribery, misappropriation of national resources, money laundering, obstruction of justice. But I expect that you would agree, as people have agreed as I've gone around the world, that corruption generally, and grand corruption particularly, have not diminished since 2005 when the UNCAC became effective. Rather, grand corruption flourishes in many countries because kleptocrats control the police, the prosecutors, and the courts, and they will not permit the honest, effective investigation, prosecution, and punishment of their friends, their families, and indeed themselves. National prosecutions in foreign countries are not sufficient to address this problem. Prosecutions under the United States Federal Corrupt Practices Act and its OECD counterparts in more than 40 countries are not remedies for holding kleptocrats accountable for taking bribes. Every one of those statutes, and I think there are now 43 of them, 43 countries, they only permit the prosecution of individuals and organizations that pay bribes, not the kleptocrats who demand them. And then Professor Reingart has raised a very important point that may not be obvious to anybody other than legal scholars, and he, among others, are educating me to try to become one. But prime ministers and presidents have immunity while they're in office from prosecution in foreign national courts. Indeed, if Vladimir Putin was brought to Ukraine to be tried for aggression under international law, as I understand it, he would have immunity from prosecution as long as he was the sitting president of Russia. But in international courts, kleptocrats would not have immunity for prosecution for their corruption. So the IACC, International Anti-Corruption Court, is urgently needed to address crucial gaps in the framework for combating grand corruption. It would be a court of last resort. It would operate on the principle of complementarity, meaning that only officials of countries unwilling or unable to prosecute high-level officials would be subject to prosecution in the IACC. A country that is unwilling would be Venezuela or Russia. A country that's willing but doesn't have the capacity would be exemplified by Moldova. Yesterday, we received a message from President Maia Sandu of Moldova saying that Moldova supports this court. It wants to work with other countries to create the court, and that's very gratifying. The International Anti-Corruption Court would enforce the 5 laws that every country is required to have by the UN Convention Against Corruption. Laws prohibiting bribery, embezzlement of national resources, obstruction of justice, money laundering. And it would have the authority to prosecute heads of state and government, certain other high elected officials or appointed officials, individuals and organizations that pay bribes, and importantly, the private enablers can conspire with them, the bankers, the lawyers, the real estate people that help launder the money. The successful prosecution in the International Anti-Corruption Court would have many favorable effects. It would result in the imprisonment of kleptocrats and thus create opportunities for the democratic process to replace them with officials who want to serve their citizens rather than enrich themselves. Sentences would include orders of restitution, repatriating or repurposing illicit gains for the benefit of countries and people victimized. And very importantly, successful prosecutions would deter, would discourage other potential kleptocrats from emulating the example of imprisoned leaders. There are 2 customary criticisms of the International Anti-Corruption Court that I'll try to address briefly. And again, Professor Reingart noted this. It's said that countries led by kleptocrats will not join the International Anti-Corruption Court. That's true, but the court does not need them to join to be effective. It's axiomatic that kleptocrats do not like to keep most of their illicit gains in their own countries. They use the international banking system to transfer their money abroad and invest it in appealing places, in London, in Western Canada for the Chinese, in Australia, and in other places. And because they've laundered their money in various countries, various jurisdictions, they're subject to prosecution in those countries. So, for example, to make this tangible, in the Panama Papers, the International Consortium of Investigative Journalism provided what I, as a judge, would say is overwhelming evidence that Vladimir Putin has laundered hundreds of millions of dollars, if not more, into or through Switzerland. If Switzerland joins the court and Russia does not, and Switzerland doesn't want to prosecute Vladimir Putin, it can defer to the International Anti-Corruption Court, and he could be prosecuted even though he didn't join the court. So the court, we hope, will be created by a good number of people, but as the professor said, it could be created initially and be effective with a small number of representative countries. The other common criticism with which I'll comment in conclusion is that this is a compelling idea, but it's an impossible ideal, and time shouldn't be wasted or money in pursuing it. That criticism has been muted lately. Almost 300 world leaders have signed a declaration calling for the creation of the International Anti-Corruption Court, including 45 former presidents and prime ministers and one sitting president. Creating a coalition of countries to create the IACC is now part of the official foreign policies of Canada and the Netherlands. They've recently been joined by Ecuador. Colombia was the first country to endorse creation of the court. And Nigeria recently said that it wished to participate in this endeavor too. And that's just the tip of the iceberg, because there's very substantial interest in this court in the UK, Senegal, Zambia, the Ivory Coast, North Macedonia, Slovakia, Timor-Leste, the Czech Republic, and Norway, for example. And there's also strong support for the court from civil society organizations. 2 weeks ago, in the final report of the Summit for Democracy Working Group on Kleptocracy, there is a call for the creation of the International Anti-Corruption Court. And next Monday, I will be speaking at the civil society session of the summit on this subject. Nevertheless, as I said, some cynics still say that while the case for the court may be compelling, it's an impossible ideal and shouldn't be pursued. But when you recognize that kleptocracy has such massive adverse effects on human rights, cynicism, I say, should not be an excuse for inaction. I'm usually the oldest person in the room when I'm speaking about this, and I probably am today. I say I've lived long enough to see certain unimaginable things happen, like the collapse of the Soviet Union and the end of apartheid in South Africa. Nelson Mandela used to say, it's always impossible until it happens. So last Friday, Danilo Turk, former president of Slovenia, of course, and the president of the Club de Madrid wrote you all a letter. And he said, we encourage the European Parliament and its members to muster the political will of European states to support establishing the International Anti-Corruption Court. Your resolution and this workshop today have the potential to be milestones in the history of protecting human rights if the members of the European Parliament and their countries heed President Turk's call. So therefore, on behalf of the legions of poor and powerless victims of grand corruption, I thank you for this opportunity to discuss the International Anti-Corruption Court and look forward to working with you in the future.
Thank you so much, Mr. Wolf. We are proud to having you here today, you and your team and all the distinguished experts we are talking to here in the room, as well as very briefly also online. Once you mentioned the amount of money that is consumed by kleptocrats and by corrupt actors, making up 8 times of what is needed to feed the hungry on the globe, we realize that this is not only technical. This is political as it can be. And if we would like to fight for human rights, we have to do something about it. And nothing must be impossible to take action that is really crucial and having an impact on what Professor Ringard and you yourself have so far described to us. I now would like to welcome Juanita Olaya from the United Nations Convention Against Corruption Coalition's working group on victims of corruption, and we hope to hear details from her. And we will, of course, listen to her views and to her experiences and be keen to getting her comments already on what has been said so far. Please, you have the floor. You are connected, we can see you, but we cannot hear you. Perhaps we can do something now. No. Yes.
So thank you very much, Mr. Bullman. Thank you, honorable members of the subcommittee, for this invitation. As a European citizen, I'm really happy and proud to see that the subcommittee is making an effort to discuss this idea as openly as possible and gathering as many different opinions and voices as possible. I also chair at the ONCA Coalition the working group on victims of corruption. So the issues of corruption and human rights are at the core of the work I do. We will agree in this room that corruption is rampant and that more decisive effort is needed to be done across the globe. But we may not agree on the means. In fact, many of us don't think that an international anti-corruption court would add value for the 5 reasons I will mention briefly, and some of them may recall already or connect to the elements that have been mentioned by Professor Wingard in his presentation. The first one, this court is more of the same that currently is not working. The problem of impunity we face is not resolved by creating another court, but by ensuring that national justice systems be strong, independent and accountable and well-connected internationally, ensuring that judges, prosecutors and witnesses and whistleblowers are protected, and supporting international but country-specific approaches that have indeed proven to be effective. Second reason, this is an idea that has missed its time. The problems that we have today can't wait to be solved in 15 or 20 years when this court would be in place. And even there, an institution formed under the thinking of the Cold War international consensus, I guess you will agree with me, with the events of today is evident, will be of little help. Third, this is an idea that sounds right. It speaks to our most inner wishes for corruption to be ended by somebody else out there. But it lacks, in essence, what it takes to be effective. No international court is feasible without strong national cooperation on the ground. And to the point that we hear, not granting standing for citizens to access justice in that court would not really be modern nor up to date. The court may be established with a few countries, but let's be realistic. Without the US, without China, and without the Emirates, it has absolutely no hope. Currently, I disagree with what I hear from Judge Wolf. It's unclear to me which countries actually do support the court. There are mentions about it, but I haven't really seen a decisive support for it by any country. Fourth reason, it is expensive and it is, we think, ineffective. We don't see it as something that can be done in addition to other things simply because it drains all resources available that are accurately needed right now for other activities and other options. So I also don't think it is feasible to do it while other things are being done simply for the amount of resources it would be draining. And look at the number of the current cases that court could take even today. Let's assume that it was functioning already in a year. How many cases could it take? 1? Maximum 5? Would that be the option we want to take? And fifth point, and perhaps a very practical one. In practical terms, what does this court mean? Where will it be placed? In Europe, I don't see there is a room for another court. Will it be in the global north? Again, this idea is sparing a lot of discussion among many organizations in the global south on being another imposition from some countries thinking that they can do better. And this again puts us in a level of the discussion that we should abandon. Will the South again be excluded? Will countries support even if it's not located there? And a very difficult question, who will really fund it? Who will really fund it? Can we risk that some countries that have currently high risk of corruption power will be funding this court? The European Parliament's recommendation of February 17, 2022, Mr. Chairman, that you also cite at the beginning of this meeting, is absolutely trend-setting in making progress towards breaking the silos between the topics of human rights and corruption. It encourages internal and external coherence, it places victims at its core, and encourages efforts in different directions. We think that the idea of a court is a step back in that direction, because it creates another silo, another separation between corruption and human rights, between corruption and its impacts. Look at the issue. Would Putin need to be tried in 3 or 4 different courts to be able to be effectively tried? Is that what we're looking for? So I don't think it is an effort to break the silos, but to contribute to bring them more. The discussion would also benefit from some real clear positions on paper. Judge Wolf mentions that there's a drafting committee for a treaty, but every time we discuss about it, what I hear is the counter arguments that I hear are, oh, but that will not be that way. It will be in another way. It will be helpful. And the fact is we're still discussing at the level of idea. There's no clear proposal where one can see, is it really going to do what it's supposed to or is made to be done? And finally, you hear me talking about we, but you only see me on camera, and hopefully the sound is working better. Indeed, it's not just me. There are many experts and organizations fighting corruption that don't think this idea is a good idea. Transparency International, in fact, in its last annual membership meeting in November 2022, issued a resolution where it urges the world to explore other options than an international court, and states as background for that the following, and I will just read briefly that excerpt. In the wake of Russia's invasion of Ukraine and the failing attempts to sanction Russia due to global illicit financial flows, there is increased political will among governments to address grand corruption and transnational corruption. Governments, international bodies, and civil society need to use this political will to make the systems in place actually work, as opposed to spending political capital on a new body that may not be established for a decade and may not yield robust results. So quite a number of experts and activists do not see in the promotion of this idea a decisive step towards fighting corruption. There will be no cheers from us. You will also not see from us an active campaign opposing it. There are more important things for us to do at the moment than organizing to oppose something like this. So that's why you will see, the quiet presentations in meetings like this, but nothing organized to oppose it. That's a luxury we cannot afford ourselves. There are many other things that require attention and resources that can be effective immediately, and the resolution has a lot of ideas in that direction already. We would urge the Parliament not to wait for another scandal to react immediately. Thank you very much.
Thank you so much, Juanita. I see us totally united on the political will to take measures, but there is a certain diversity what kind of measures that should be. And having said that, I'm keen to listening to our last expert. We invited Juan Francisco Sandoval, former head of the Special Prosecutor's Office Against Impunity in Guatemala. Mr. Sandoval had to leave his country because of his work against corruption. His name was mentioned in European Parliament's resolution on the 7th of April in 2022 on the situation of the rule of law and human rights in the Republic of Guatemala. Please, Francisco Sandoval, take the floor and give your opinion to our discussion.
Muy buenos.
Greetings, good day, good morning here in the Americas, and good afternoon to you in Europe. I'd like to thank you for giving me this chance to speak to all of you today, and really for having underlined the importance of this debate, this very important debate about the possibility of setting up an international anti-corruption court, which I think is an appropriate measure considering the experience that I have lived through. I am currently in exile in the United States, political exile, and this is a direct result of the work that I was doing to fight against corruption in my country. I am referring to this situation because different alternatives have been discussed to an international court, such as empowering regional courts, for example, to be able to exercise their jurisdiction on corruption matters, or have been the idea of fostering different investigation methods to fight against impunity, which has been the case in Guatemala. This was successful in my country. This was a UN-led initiative. But the success of this in Guatemala meant that the people in power who are corrupt, and the previous European Parliament did in fact make a resolution which pointed directly how the Guatemala authorities had taken actions to defend a corrupt regime. Criminalization and discrediting exile. This is what they do. This is their modus operandi. And this is directly linked to the need to have an international mechanism or as a permanent court that can prosecute these constant, serious, grave events that happen not just in Guatemala but all over Latin America and indeed all over the world. I think that's different to what happens in Europe. Let me underscore my personal experience, because if I wanted to denounce the systematic violations about corruption in my country, there are 30 of us are exiled, 30 members of the judiciary who have pointed to this corruption activities in our country. We have nowhere to go. Some people have made different proposals. Some may seem a little out there, but we're talking about persecution that we are suffering from Guatemala. And under the Rome Statute, we should be protected. But this is not going to resolve the situation in Guatemala, where it is simply currently not possible to investigate acts of corruption. Neither is there any kind of alternative for these serious cases of transnational corruption to be investigated in a jurisdiction other than that of Guatemala. Because what these countries that are a sort of a bridge for committing these cases of a grand corruption are simply not interested in doing that. So we're talking about the setting up an international anti-corruption mechanism via a permanent international court. That might not affect Guatemala, but in Honduras, say, which is a neighboring country, there is a mechanism that is sustained and supported by the Organization of American States. But the current government in Honduras, they had to leave, or they decided to leave it alone, and this thing has just not moved forward, and they cannot investigate acts of corruption there. The same thing happens in El Salvador, which also under the auspices of the Organization of American States, they set up a mechanism, but it was a temporary mechanism, and this has caused serious effects, because in El Salvador you can't investigate acts of corruption either. So setting up an international anti-corruption court particularly would help in the weak, corrupt, politicized and kleptocratic systems. That would help to facilitate justice in those countries if there were an international body which could dissuade these governments if the court were to decide that the justice system of a certain country is not fit for purpose or is not acting according to standards, which would really help to fight against corruption, which is costing lives, particularly in the third world. So an international court under this complementary jurisdiction, I think, could have a catalyzing effect. It could motivate countries to improve the effectiveness of their national justice systems. It's true that this is seen as something as a utopia right now. People wonder if it's really politically viable. It wouldn't be very effective to have these, looking at the previous mechanisms. And the participation or acceptation of this kind of court's jurisdiction, they think would be very difficult for certain countries to accept. For example, Guatemala, my country of origin. Or some people say, well, what they're trying to do is, this is the Western countries trying to set up this court so that they judge things which are none of their business and are outside their purview. That could be a cause of discussion because of the difficulty in investigating these cases of corruption. They could be documented, but imagine the headache that would provoke for an international jurisdiction to have access to proof, to documents that could prove what had been brought to light. But really, we come up against a brick wall here. We see what's happening in many, many countries around the world. And that is the direct link between corruption and the minimal access to human rights. They're closely correlated. The countries where corruption is rife and the countries where there are systematic violation of human rights. There's a direct correlation there. It's quite, it's all very well having a day of anti-corruption, or we have, an international day for human rights, and they're linked together because there is a direct link between these two phenomena. So what I'm saying is that in many countries, the only alternative that really exists to fight against corruption and to bring corrupt people to book is to set up an international court of this nature. Thank you very much for your time.
I thank you. Thank you so much, Juan Francisco Sandoval. Thanks to Juanita Olaya, to Judge Wolf, and to Cedric Ringert. We have heard different voices with different conclusions. I go back to our first speaker, to Professor Ringert, because I understood him in a way that he said, well, make full use of all what you have and give a chance to new tools as well. Install new measures additionally, not instead. And to go straightforward as good as you can. I heard also the skepticism about introducing a new international court, but perhaps I could open the debate on the floor with my colleagues with the remark that we look back to last Friday into what the ICC did with the arrest warrant against Putin and the so-called commissioner on the right of the child to Putin. And many of those who always have said international jurisdiction cannot do anything, and how can you move forward without China, without Russia and the US, were astonished about the political wave that was created by this bold move. So we are in a vivid debate, in a vivid discussion of what kind of conclusion should be the right one. And that should also be a productive discourse about the right thing to do and the most effective measures. Heidi, you are our first speaker.
Yeah, thank you very much. I think it's very fruitful to have this slightly contradictory views, because it helps us to understand what we are actually talking about. So I think indeed what you, Chair, have said, that one of the approaches is that let's do what in fact Dr. Olaya Garcia said, that let's make sure that the national justice systems will be independent and capable to address corruption. And I think we have a lot to do. Professor Ringard mentioned that there was this, and I would say very unfortunate, ruling from the European Court of Justice in December, I believe, which actually put us as co-legislator in a difficult position, because we have even quite recently adopted legislation, for instance, on country-by-country tax reporting, which now is a bit of an, we don't know how that can be used, because indeed there was this question that now all of a sudden the court says that we have to somehow protect the privacy of the ultimate beneficial owners. So we as legislators have to deal with this. And actually you said what we can do, that there will be the, I guess, 6th money laundering package. So it has to be remedied. But that's just one thing. But then, Chair, you also said that make full use of existing instruments and perhaps complement with them with something additional. So my question would go to, let's say, to the both sides of this debate, to our 3 first speakers, and then to Dr. Olaya Garcia. That so, what would be the benefits of the, let's say, I hope I'm not misunderstanding, but the 2 like different approaches on the potential to address transborder grand corruption? Do we need the International Anti-Corruption Court for this, or can we address those with the, let's say, the UN Convention of Anti-Corruption tools? And so, because I believe that now what we have to do is to find ways to prosecute crimes that go across border. And do the existing instruments allow us to do that, or do we in fact need such an, let's say, transnational court? And I understand that this is a very demanding task, but what can we do with existing instruments such as the UN Convention against Corruption? I have many more questions, but I leave it to this.
Thank you, Heidi. Marisa, would you like to take the floor as well?
Yes, I would. Thank you very much. Very briefly, I would also, of course, like to thank the various speakers for their words. I'd like to thank the speakers for their words. I think it's been very interesting, a very rich debate, and very interesting to see all these different perspectives on this. So allow me to make the most of this opportunity just to raise a few very specific questions or issues which I think could help to feed into this debate. First of all, what was said initially about the need to have a common definition of what corruption is. A mechanism, no mechanism can work if it's a transnational unless we have a very clear common definition. My question, therefore, is how do you foresee the possibility of having an internationally recognized definition of corruption? What is the procedure to achieve that? Corruption, of course you can't have an anti-corruption court unless you have a clear, legitimate definition that recognizes that definition. A couple of other questions I have in detail. I'm just curious to know, first of all, that's linked to these more institutional matters. What kind of anti-corruption institutions would be a minimum requirement? We're talking about very different realities from different countries, from one to another, but institutionalization of a court on a higher level would also need to have effective anti-corruption institutions, are the elements of this body, of this court. And finally, the fact that we're all very, very worried and concerned about corruption, we need to have mechanisms to fight against this corruption. People have pointed to the links, directly or indirectly, between corruption and human lives. But we believe, or would like to believe, that we live in a world in which corruption is getting less and less rather than getting more and more. But we're looking at a crime. We need to have mechanisms. What mechanisms are being considered for preventing these crimes? It's all very well talking about laws and courts to say this is what we do after corruption has been committed. Corruption crimes. We need to think about how we can actually prevent the crimes happening in the first place. So I wonder how you see that.
And we gathered a lot of interesting points and questions. So I would like to now give the floor back to our experts in the reverse order, if you allow me. If Juan Francisco Sandoval is still with us, I would give him the floor first. Is he still connected?
Muy bien.
Thank you. Well, the question of whether these tools are insufficient, well, let me reaffirm that this subject of the International Convention Against Corruption, while it's true that that is a big step forward, many laws have safeguards clauses which limit the put limits on the state's party. There might be internal rules, but this non-obligatory character means that it's not obligatory to penalize bribery or misappropriation or embezzlement. Also, in terms of the corruption in the financing of political parties, there are different states' parties that are not respecting what they signed up to when they agreed on this. There are subjects such as extradition and the obligation to cooperate. But we also need to have cooperation in terms of judiciary measures. But at the end of the day, they don't really have the effect that they're supposed to have in terms of pursuing and prosecuting people who have basically bought the whole thing in their countries. They've bought the judicial system. So we need to talk about other subjects such as prevention of crimes. That, of course, is fundamental. But right now, looking at the situation, the dynamics in countries, I keep mentioning Guatemala, but many other Latin American states can be replicated across the globe. And as I said at the start, setting up a court of this nature, I think, could have a dissuasory preventive effect, and it could have a catalyzing effect that could really help to protect others against the effects of corruption. Thank you.
Thank you very much, Juan Francisco Sandoval. Now, the floor is back to Juanita Olaya. Are you still with us? Yes, I can see you. And one question additionally, perhaps to you. If your skepticism wasn't removed by the discussion so far, which might be the case, since you have not started to think about it half an hour ago, could you perhaps add from your position how existing instruments might be strengthened, by what kind of measures, by what kind of decisions, in the way you would like to see it? That would be of additional interest for us as well. Please, you have the floor.
Thank you so much, Mr. Chairman. I'll try to go through all the questions briefly so everybody can speak. On the first question from Representative Hautala, I think, on whether, which connects to your current question a little bit, are current mechanisms insufficient? Let me mention 2 points. One, a recent study by the OECD, I think it's from 2017, revealed that the very little enforcement, the very little anti-corruption enforcement that today exists, of that very little enforcement, 80% is finalized through extrajudicial agreements, agreements out of court. And the main reason being that proving corruption the way we have it is so difficult, is impossible, that the only way to get out of it is through agreements. I don't see how an international anti-corruption court would overcome that obstacle. I only see it would face it in an enhanced and bigger version, because in fact an international anti-corruption court, and you could see it even today from the doings of the International Criminal Court, depends on national anti-corruption and national anti-corruption institutions, which also connects to a point raised elsewhere. When it comes to alternative mechanisms, I think Professor Wingard mentioned most of them, and they are quite useful. Transnational jurisdiction that can be much more used. Hybrid mechanisms. I don't think that the argument that the court in Guatemala was later ended is an argument to say that it didn't do a good work. Actually, is the show that it demonstrates that it really worked. What was needed was much more protection for those judges and prosecutors like Juan, for them not to be able or not to need to go to exile, and to be able to be taken care of differently. So one would need, and I'm trying to link the questions a little bit, one of the crucial things to do, and of the immediate things to do, is to offer much more decisive protection for judges and prosecutors, human rights defenders and activists on the ground, so that they really know they can count on the strength of international support for their work, and that they will not be risking their lives. I am a believer of a mechanism that is rarely used, which is the universal jurisdiction. And I think, countries like Canada and many others in Europe also that have that mechanism could use it also to deal with matters together at the same time, human rights and corruption issues. This is what I meant precisely when I mentioned the Putin case, and that, Mr. Chairman, you quote us as a politically bold move that we're seeing on the International Criminal Court. Imagine if the International Criminal Court could judge Putin for everything, including the corruption he has incurred in, and that we didn't need to start from scratch in another court based elsewhere with different evidence, with a different process. So we're talking about speed, resources, timing, which is, I think, of the essence of necessary anti-corruption work. Creating a separate court is also not the other option. I know there's mixed opinions about the role of the International Criminal Court, although we're seeing right now that it's working much more effectively. One could even consider the idea of extending more explicitly the mandate of the International Criminal Court to allow it also to prosecute corruption charges, again, from the perspective not of the silo that's just corruption, but from the perspective of its impacts to society, the human rights impacts to society, which is, and that would be not only much less expensive. The International Criminal Court functioning costs nowadays 150 million euro. I don't know where will we manage to fund this new International Anti-Corruption Court. Finally, I've been working on issues of anti-corruption for about 30 years already, from the front lines. And I've changed my mind about 6 times about how it would work best out of working in the field. I do believe that enforcement is necessary. So it's not the argument saying that the International Anti-Corruption Court is not needed, doesn't need to be understood as saying enforcement is not needed. Quite the contrary, enforcement is needed. But indeed, as Representative Matias suggests, prevention is also needed. We live in a world that does not reward integrity. We live in a world that is thriving on ambivalence. We're not strong enough in criticizing corruption, in excluding that behavior, sanctioning. In fact, if you look at the diplomatic level, countries are very ambivalent in their relationships among each other. They tolerate a lot. And this is part of the problem. Actually, you see it also with Putin nowadays, with Russia's membership in the National Security Security Council. This ambivalence cannot be tolerated. So, among the things that and the questions or the things that one should consider, and I would also go back again to Professor Ringer's list, which I felt it was very good and comprehensive of things that need to be enforced. Definitely the publicity of beneficial ownership registries, definitely the protection of whistleblowers, witnesses, judges, prosecutors, human rights defenders, but much more effectively, much quicker. I've seen it also on my daily work. Definitely an enforcement of a more comprehensive sanction systems in the EU would be of definitely help for this. And I would suggest to keep open the possibility for hybrid mechanisms where the international and national authorities do work together, but they need to be tailor-made to the situations according to what is necessary, according to the possibilities, and also learning from what is happening. I am sure that a new court along the lines that was the one that worked in Guatemala would need today to be set up differently to impede the possibility of a change of government to dissolve the court. And finally, a point on geopolitics and in politics that I would like to share now that Mr. Chairman also you mentioned this. I attended in Colombia a few years ago, I think it was 2019, 2018, a meeting similar to this one to discuss this idea. Back then, Colombia was supporting the idea of an international anti-corruption court. It isn't anymore, at least to my understanding. I saw a phenomena that worried me there, which was many Central American countries, and this was 3-4 years ago, before what we're seeing today, the horrible prosecution that Guatemalan prosecutors and judges, former judges of that court, are being are facing. Back then in Colombia, several representatives of Central American countries stood up to defend this idea and to say that it was positive, not on the argument of different merits that it could have for them in their eyes, but on the arguments. The main argument was, and they mentioned this explicitly, the main argument was because that would be a way to avoid a court like the ICIG. And that made me really worried, because they saw that this was a possibility of avoiding responsibility. I hope I have happy to come back, but I don't want to take all that time.
Thank you so much, Juanita Olaya. And thanks for all the courageous commitment in the front line. Once you mentioned you have changed your mind about 6 times of what practical consequences have to be drawn. Only my very modest comment, this happens really only to the courageous people, the non-dogmatic ones who are really searching the truth and the right consequences of shifting realities. So all the best for your work. Judge Wolf, since you have been not only the originator, but also the promoter of the idea, what is your takeaway from our discussion today?
Well, one thing I think we should all take away is enormous admiration for one Francisco Sandoval. You've heard from four of us, but in him, you've heard from a heroic victim of grand corruption. He was with international support that was invited in originally by Guatemala, investigating and developing prosecutions of the president of his country because of his corrupt relationship with drug cartels. And now he's in exile. And he said there were 30 other judges. One of them, Claudia Escobar, is a vice chair of Integrity Initiatives International, and another eloquent proponent of the International Anti-Corruption Court. Mr. Sandoval, Francisco Sandoval, said something else that I didn't touch on in my opening remarks. There's evidence, I find persuasive, that the International Criminal Court has provided incentives to countries to improve their own performance in the human rights area to avoid prosecutions in the ICC. Colombia is perhaps the most prominent example. And the existence of an international anti-corruption court would both provide an incentive for countries to improve, and we view the expert investigators, prosecutors, and judges as a sort of super CSIC. They would work with counterparts in those countries that are willing but unable, the Moldovas of the world today, to strengthen their domestic capacity. The point was raised that prevention is very important. I completely agree with that. The consequences of grand corruption, like the consequences of other forms of violations of human rights, are impossible to deal with in a satisfactory way, fully satisfactory way after the fact. But fundamentally, the International Anti-Corruption Court is a prevention mechanism. It's the basic principle of the criminal law that when people are threatened with serious punishment, they will behave properly. And if they're not threatened, they will violate the law. War crimes are never excusable, but war crimes by definition are committed in the heat of passion. Grand corruption is different. It's a crime of calculation. There are dishonest, greedy people who've gotten into power, and they see there's lots of money that they can take, and there's no credible threat that anything will happen to them, and they take it. And they rob children of the education they deserve. They rob people of their health care. They rob them of their right to life in many cases. But fundamentally, the court is a prevention measure. There was a question about the importance of getting an accepted definition of the corruption that would be within the jurisdiction of the International Anti-Corruption Court. It exists. The UN Convention Against Corruption has definitions of the 5 mandatory crimes like bribery and embezzlement and misappropriation, obstruction of justice, money laundering. And the proposal is very specifically that those 5 crimes are those that would be in the jurisdiction of the International Anti-Corruption Court, because 181 countries that are in the UN have laws on the books making those things crimes, and they should all be fundamentally comparable to the UNCAC definitions. The problem is that the laws are not enforced, and strengthening existing mechanisms is something we support, but it hasn't happened in the last 20 years. I've yet to meet anyone around the world who said they think there's less grand corruption now than there was when the UNCAC came into force. Because in the countries led by kleptocrats who are unwilling to let those laws be enforced against their families, their friends, and themselves, this thrives. And when I published my first 2 articles on this in 2014, seems like a long time ago, but only in the last 2 years has this gone from a concept to a growing campaign with very substantial support from the Global South. When I published those articles, I did not know that years later I would have this opportunity, but also this compulsion to appear in the European Parliament. If somehow the people who had professional responsibilities for this, both in governments, in international organizations and NGOs, had been more successful in seeing the laws required by the UNCAC actually enforced, I could be enjoying what my wife would like to enjoy, a tranquil retirement. But I hear, and he's just one personification of the victims of corruption. I hear Mr. Sandoval, and he's so brave. And I just feel the agony of the world, of the victims of grand corruption. And unless there's a credible threat that they're going to be prosecuted and punished, nothing will prevent them from continuing. I could say more, but I'll stop.
Thank you so much, Judge Wolf, and especially also for your very, very well-received words on Mr. Sandoval and his lifetime commitment on the fight against corruption. All that is well received, and thanks to all of you, Juan Francisco Sandoval, to Juanita Olaya, to Mark Wolf. But finally, Professor Ringard, since everybody refers to you, since you know, also from divergent points of view, since you know that the Commission is going to prepare an anti-corruption package, hopefully seeing the light of the day very soon, since you know that the External Action Service is preparing something for this summer, we hope, lately, for 2 minutes. Imagine you would be the chief advisor of High Rep Borrell. What should he do?
Difficult question, obviously. I think it's not, in this discussion, not a matter of and or, but perhaps a matter of and, that you have to focus on a number of strategies. So you may have to think, indeed, about the IACC, although that is a long-term project, but we shouldn't forget about it, while not neglecting other mechanisms, and I list quite a number of them in the report, but perhaps I should highlight a number of these. I think the EU, or the EU member states, in fact, should do a better job in terms of prosecuting foreign corrupt practices, and I think other countries have led the way in this respect. Really, the member states have a rather dismal record, and I would really like to emphasize that. I think the review mechanism at UNCAC could be strengthened as well, and I think Juanita has written many interesting things about that, also involving civil society, which is really important for the European Union as well. Strengthen regional mechanisms, of course, with the scandal in the EU, of course, focus, put your own house in order, that's clear, but also collaborate with others. And there is, for instance, an interesting regional peer review mechanism in Africa, to which Nigeria recently referred the Nigerian representative who was actually supporting also the International Court, said we also, at the same time, have to invest in regional mechanisms. So again, it may be end-end. And fourth, I think the EU could also support specialized courts in its near neighborhood. Think about Ukraine, for instance. There's an interesting report by U4, which is an NGO in Bergen, Norway, report written by Matthew Stevenson, who's, by the way, not a fan of the IACC, but he does interesting work on anti-corruption, and he has a very interesting comparative report on supporting specialized courts in other countries and outside the EU. The IACC, is it really needed? Does it have added value? I think that's the key question for all of us. I think it expresses symbolism. It has a signaling function. It signals that we have to take corruption seriously. So it's really the international community expressing its international moral condemnation. You also mentioned in the arrest warrant issued against by the ICC, prosecuted against Putin. So think about, again, an arrest warrant against Putin regarding corruption, which is a distinct possibility if an IACC is set up. So this may also have major preventative and deterrent effects. And I think this links up with what Judge Wolf was just saying. I think such an IACC, as Mr. Sandoval said, can catalyze, these are his words, strengthen national prosecutions on the basis of complementarity. So I really see added value there, and I would really like to emphasize also the notion of positive complementarity, that the court actually works together with the national courts and not in opposition, but in collaboration, and we already see that with the ICC, which offers us a good model. I'm aware that it is a real concern that resources may be diverted away. That's the key concern also of Juanita. But I think at the end of the day, this is really a political question, and I think we have to conclude that overall more resources might be needed. I just put it on the table, but that's a political reality. I have real concerns, finally, also regarding difficulties of cooperation. I really recognize that, especially if many member states, or many states might not ratify, and even if they ratify, as we've seen with the ICC, they might not actually cooperate. So that's really a concern. But then, of course, we could follow the money to the territories of state parties, and Judge Wolf was talking about Switzerland. I'm not sure whether Switzerland has actually supported the court, but this is really a country that you really wish to convince to join such a court. It's not just a Western construct, by the way. There are other countries outside of the West who have supported this. Ecuador, Nigeria has been mentioned, Moldova. So this is interesting to think about. So on balance, I would say that I'm cautiously supportive of establishing, in principle, the IACC, but I would like to see the statute first, but you're frantically working on this, I understand. Thank you.
Secretary Ringert, thanks all of you again, warm-heartedly. I think I can speak on behalf of the colleagues here of our subcommittee as well. It was a very fruitful, a very vivid exchange of views, and we will make, this is our promise, we will make use of it. And we have a coordinators meeting tomorrow, and my prognosis is that we will come back to the issue, continuing discussing that, and hopefully come to a final conclusion here in our subcommittee before Commission and External Action Service are going to raise their voice. Thanks again for having the opportunity to talk to you today on the screen, here on the floor, and all the best for your work. And I close the meeting of today.